Text Hobby.
Our Lady of Lourdes Hospital vs Spouses Romeo and Regina Capanzana. GR number 189218, March 22, 2017, Serrano, CJ. In an action for damages against a hospital. The negligence of its nurses can be imputed to the employer where there is no proof that the employer exercised actual supervision and monitoring of consistent compliance with hospital rules by its staff. Facts: Regina Capanzana was brought to Petitioner Hospital for an emergency C-section. She successfully gave birth to a baby boy. 13 hours after her operation, she asked for oxygen, and complained of a headache, a chilly sensation, restlessness, and shortness of breath. It took around 10 minutes for nurses to respond to the call and administer oxygen. She was eventually transferred to the intensive care unit, where she was hooked to a mechanical ventilator. When her condition still showed no improvement, Regina was transferred to the Cardinal Santos Hospital. The doctors thereat found that she was suffering from rheumatic heart disease, mitral stenosis with mild pulmonary hypertension. This development resulted in cardiopulmonary arrest and, subsequently, brain damage. Regina lost the use of her speech, eyesight, hearing, and limbs. She was discharged in a vegetative state and eventually died. Respondent spouses Capanzana filed a complaint for damages against Petitioner Hospital, along with co-defendants, the nurses on duty. They allege that the nurses were negligent for not having promptly given oxygen, and that the hospital was equally negligent for not making available and accessible the oxygen unit on that same hospital floor. Issue: whether or not Petitioner Hospital is negligent. Ruling: yes. Proximate cause has been defined as that which, in natural and continuous sequence unbroken by any efficient intervening cause, produces injury, and without which the result would not have occurred. The omission of the nurses, their failure to promptly check on Regina and to refer her to the resident doctor and, thereafter, to immediately provide oxygen was clearly the proximate cause that led to the brain damage suffered by the patient. As to the nurses, the RTC and CA found that there was a delay in the administration of oxygen to the patient. When she was gasping for breath and turning cyanotic, bluish, it was the duty of the nurses to intervene immediately by informing the resident doctor. Such high degree of care and responsiveness was needed cannot be overemphasized because it takes only 5 minutes of oxygen deprivation for irreversible brain damage to set in. Regina herself had asked for oxygen, but even if the patient had not asked for oxygen, the mere fact that her breathing was labored to an abnormal degree should have impelled the nurses to immediately call the doctor and to administer oxygen. They committed a breach of their duty to respond immediately to the needs of Regina. Regina suffered from brain damage, and the proximate cause of the brain damage was the delay in responding to Regina's call for help and for oxygen. As to the hospital, for the negligence of its nurses, Petitioner is thus liable under Article 2180, NCC. An employer like Petitioner Hospital may be held liable for the negligence of its employees based on its responsibility under a relationship of patria potestas. Once negligence of the employee is shown, the burden is on the employer to overcome the presumption of negligence on the latter's part by proving observance of the required diligence. The hospital failed to discharge its burden of proving due diligence in the supervision of its nurses and is therefore liable for their negligence. While the hospital offered proof of diligence in hiring, there is no proof of actual supervision of the employee's work or actual implementation and monitoring of consistent compliance with hospital rules. The hospital is directly liable for the negligence of its nurses.
Text Hobby. Hit like and subscribe.